600.211. This is a clause in Migration Regulations 1994 used by the case officers to refuse a visitor visa application. So this is one of the common reasons for a visitor visa refusal. So what is 600.211 and how many subclauses does it have? It has 3 subclauses A, B and C. And what 600.211 says is the applicant genuinely intends to stay temporarily in Australia for the purpose for which the visa is granted, having regard to A, whether the applicant has complied substantially with the conditions to which the last substantive visa or any subsequent bridging visa held by the applicant was subject, and B, whether the applicant intends to comply with the conditions to which the subclass 600 visa would be subject, and C, any other relevant matter. My name is Sujith Billa. I'm a registered migration agent here in Australia. This video is about a tribunal case. A visitor visa refused and the applicant went to the tribunal. The applicant, an Indian national, had entered Australia on 1st August 2014 on a subclass 457, which ceased on 1st Feb 2016. He was granted a visitor visa on 11th Feb 2016, which ceased on 2nd May 2016, during which he made another visitor visa application to extend his stay from 2nd May 2016 until 31st July 2016. So that visa, which he wanted to extend his stay from 2nd May 2016, was refused. So the reason the case officer gave is not satisfying 600.211, which requires the visa applicant to satisfy the department that the visa applicant genuinely intends to stay temporarily in Australia for the purpose for which the visa is granted. Noting that the applicant had applied for the visa to wait for an invitation for the permanent subclass 190 visa, the delegate, which means the case officer, refused to grant the visa on the basis that the applicant did not meet 600.211 because the visitor visa program did not support applicants remaining onshore to wait for a permanent visa. So the basis of this visa refusal is 600.211, and the case officer said, look, you said to us that you're waiting for an invitation for 190 and visitor visa is not for that purpose. So you can't just apply a visitor visa and stay in Australia and wait for an invitation to apply a permanent residence visa like 190 in this case. That's why the visa got refused. So the applicant now is talking to the tribunal, and the applicant is now saying to the tribunal, look, actually I was waiting for 190 visa, but also I was wanting to travel in Australia. Okay, so he said this. So he gave new information to the tribunal that his intention was also to travel in Australia. Now, the tribunal is looking into 600.211, and it was talking about 600.211 of A, subclause A, and subclause A is about compliance in previous visa. So the tribunal said, look, in the previous visa, visitor 1, you got this condition 8101, which says that the holder must not engage in work in Australia. So the tribunal wanted to know whether the applicant worked while on his previous visitor visa. And from the time his 457 visa got expired and now, which means the time he was with the tribunal, it was 8 months. So the time was calculated when he got the first visitor visa 600, and then when he applied for the second visitor visa, he got a bridging visa A. So that time on 600 plus the time on the bridging visa A was around 8 months. And the tribunal wanted to know whether in that 8 months the applicant really did not work because he's not allowed to work. So they wanted to look at his bank statements, but the applicant did not provide bank statements. Even in his visa application, he did not provide bank statements, and he told the case officer that he will self-fund and he's unemployed and he's self-fund and he's got money in his Australian bank account, but he did not provide the bank account details, bank statements in the visa application, and also he did not provide the same to the tribunal. So the tribunal was not satisfied that the applicant satisfied 600.211 of A. The tribunal then looked at 600.211 of B, which is intention to comply. Again, because 8101 was not satisfied on the previous visitor visa, or the tribunal thinks that it is not satisfied that he did not really work, so they have got genuine doubt on the applicant whether he will have the intention to comply in the future visitor visa if he is granted one. So the tribunal was not satisfied that the applicant satisfies 600.211 of B. Moving on, 600.211 of C, which talks about any other relevant matter. In this case, ties in India is one of those relevant matters. So having an incentive to go back to your home country is something that the case officer looks at. And here the tribunal is doing the same thing. So they are looking at ties in India because the applicant is from India. The applicant testified that he is unmarried and has no children. So he testified it to the tribunal that he is unmarried and has no children. His family is in India, consists of his parents and sister. He says he is close to them, but the tribunal member gives these ties little weight as an incentive for him to return to India, given that he stated in his written submission to the tribunal he has daily contact with them via Skype. He also stated that in submission that his parents have 3 properties and he may be needed to care for those estates. The tribunal member found this vague and speculative and hence not a strong incentive for the applicant to return to India. Also, the fact that the applicant has not indicated that he personally owns any assets in India or he has any employment or other ties there. Overall, the tribunal member found that the applicant ties in India provide little incentive for him to return there. Therefore, in this case, the tribunal member was not satisfied that the visitor visa applicant genuinely intended to stay temporarily in Australia for the purpose for which the visa is granted, and found that the requirements of clause 600.211 are not met. Therefore, the tribunal agreed with the decision of the case officer to refuse the visitor visa application, Class FA. That brings to the end of this video. The moral of the story is you should have genuine intention to stay in Australia, and 600.211 is the clause that talks about the genuine intention, and it is one of those reasons the case officer can use to refuse a visitor visa application. So it's very important to comply with the previous visas, not to work on a visitor visa. And if someone tells you to come to Australia and then get on a bridging visa and then work somehow, then don't believe it, because you can't come to Australia having the idea of getting onto a bridging visa and work, because visitor visa is not about working. Number 2, you have to show incentive. Incentive means what are the ties you got in your home country and why is it important for you to go back to your country, and that will tell the case officer that you're not going to stay here permanently. For those who do not know me, my name is Sujith Billa, a registered migration agent living in Australia. Thank you for watching my video. Please subscribe to my channel Sujith Talks on YouTube, and if you haven't done that yet, please do it. If you have done that but did not click on the bell icon, Please click on the bell icon to get notified. If you're after immigration advice, if you would like to know whether you're eligible for a visitor visa, or you want to know more about this genuine intention to stay temporarily in Australia 600.211 clause, please go to my website sujithtalks.com and schedule a phone consultation. Once again, thanks for watching. I'll see you in the next video.